Let's take a look at the public policy exception from an employment law perspective. Employees are also citizens with rights and responsibilities to the larger society. Sometimes the roles of employee and citizen conflict. Employers occasionally want their employees to act in ways that are contrary to the public good. Under the public policy exception to employment at will, employers are liable in tort for wrongful discharge when they terminate employees for taking actions that public policy requires or highly commands. Allowing the terminations to stand would offend and undermine important public policy. Courts insist that claims be firmly grounded in fundamental and well-established public policy. To be protected, employees' actions must pertain to the public or society at large, rather than merely their personal interests or internal company matter. Primary sources of public policy are statutes and constitutions, although regulations, court decisions, and even professional codes of ethics are sometimes recognized as grounds for public policy claims. Although constitutions are the most basic source of law and public policy, courts have generally not permitted private sector employees to use constitutions as the basis for public policy claims. The jeopardy element suggests that even when an employee's actions relate to a clear public policy, the employee will not be protected unless allowing the termination would tend to undermine the public policy in question. Courts will inquire into whether alternative means exist to promote the public policy. The causation element is common to any type of retaliation claim and would be satisfied as evidence regarding the timing of the termination and other indicators of a motive of retaliating for the action taken in support of the public policy. If an employee can establish that the first three elements are true, an employer can still prevail by showing that the termination was also motivated by another overriding factor. Employees must not be terminated for refusing to commit illegal acts, exercising their legal rights, performing important public duties, or reporting illegal activities of employers to their agents. The first case in which a public policy exception to employment at will was recognized involved the termination of an at-will employee for refusal to commit an illegal act. Public policy wrongful discharge claims are also recognized when employees are terminated for exercising legal rights. Successful claims have been raised by employees fired for such things as filing workers' compensation claims, exercising their voting rights, and having wages withheld or garnished for child support. The most nebulous and least often recognized variety of public policy claims is termination for performing a public duty. The duty in these cases is something that is not strictly required by law, but is clearly undertaken in the public interest. This last type of public policy claim is termination for reporting illegal activity or whistleblowing. Whistleblowers report activities engaged in by employers or their agents that are illegal or otherwise injurious to the public.